So you're sitting at home, you're relaxing with friends, when all of a sudden you hear a banging at the front door. And it's a police officer, and he's yelling to let him in. And he says, you've got 5 seconds, and he starts counting down. What do? Do you have to let him in? Doesn't he need a warrant for that? Well, we're going to answer those questions and more in today's episode. I'm Joshua Roberts, attorney at law. That is the Inquisitive Monkey, and you are watching Lawyer Up. Today we're going to talk about the Fourth Amendment, which prohibits warrantless searches. We're also going to be talking about the exceptions to that warrant requirement. And we're going to have a little fun today. We are going to be looking at a video and we're going to do a reaction to that video to help illustrate the points behind the Fourth Amendment. Now, the video comes to us from my brother in the bar. His name is Brian Wilson. He is a lawyer in the Fort Worth area, and he goes on YouTube by the handle the Texas LawHawk. If you haven't seen his videos, you should definitely get over to his channel. He is one of the most entertaining lawyers on YouTube, and his material is hilarious, as you will soon see. Remember to like, comment, subscribe, and share me on social media. And we've got merch. If you want to support the channel, the link to bossindustries.co is in the description below. We've got hats, we've got shirts, we've got coffee mugs. And remember, every penny of merch sales goes back into making this a better channel for you. So without further ado, let's get to the video that illustrates the Fourth Amendment's warrant requirement. So he's running with the American flag. That's patriotic, that's fairly normal. Well, that's where the normality
Brian Wilson,
is.
Boom! Talons of justice.
Talons of justice.
Brian Wilson, the Texas LawHawk. Hunger for justice.
He caught a fish.
Brian Wilson, the Texas LawHawk.
Okay. So that's just the introduction. It is awesome. He's running with the flag. It's patriotic. It's fairly normal. And then there's the mass explosion. We hear a falcon screeching, and then we get the talons of justice. Then he introduces himself. He's Brian Wilson. He's not the Beach Boy. He's not from that band. He's the Texas LawHawk, for goodness sakes. Then he talks about his hunger for justice and snatches a fish out of the river. I suppose that's what a hawk would do. Then you see him growling. And that's not really what you see from a hawk or a lawyer, for that matter. However, at this point, you have my undivided attention. Now let's dive back in and watch more. There's the cop. Oh, this looks mischievous. Hungry hippos. Uh-oh.
Noise complaint. Open up, or everyone's going to jail.
Doesn't he need a warrant?
Y'all got 5,
I don't know.
4, 3.
Hey, it's his lawyer. Boom!
Someone just called me. 2. You know you need a warrant for that. Know your rights. Call Brian Wilson, the Texas LawHawk today. Brian Wilson. The
Texas LawHawk.
Arrested? If so, call Brian Wilson, the Texas LawHawk today.
Brian Wilson, Texas LawHawk.
All right, so that video was awesome. We were involved in a intense game of hungry hippos with a rough crowd. You can see that one guy even had a ponytail when there is the beat at the door from the police officer. So aside from having a pretty cute dog, the cop beats on the door and starts counting down from 5 to let him in. The guy inside, correctly says, hey, wait a minute. Doesn't he need a warrant? And then he calls his lawyer, who just happens to be Brian Wilson, the Texas LawHawk, who I think busted through a wall, kind of like the Kool-Aid Man, to enter into the living room. Then he busts through the door, squashes the cop, takes his cute puppy dog, and reminds us all that they need a warrant for that kind of activity. And then at the end, he jumps out of a moving vehicle and reminds you that he is Brian Wilson, the Texas LawHawk. And I love this YouTube video. And more importantly, it illustrates a very good point when we're talking about the Fourth Amendment and we're talking about the warrantless searches that the Constitution protects us from. Now, when we're talking about the text of the Fourth Amendment, I'm just going to read it so we have the verbatim information out there. It says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Now let's break that down. All right? In its purest form, this constitutional amendment prohibits the government. It prohibits law enforcement from unreasonable searches and seizures of American citizens. Now, if you are going to search, basically, you need a warrant. Now, we're going to talk about some exceptions to that a little bit later, but on its face, fundamentally, a search requires a warrant. And the Fourth Amendment also sets forth the requirements for obtaining this warrant. It says that warrants must be issued by a judge. It must be justified by probable cause, that some information or some reason to believe that criminal activity is afoot. It must be supported by an oath or affirmation of some witness, usually be a police officer or law enforcement, swearing under the penalty of perjury that the information provided is true. And it must particularly describe the place to be searched or the person or things to be seized. It can't be this general warrant that says you can search everything in Nixon, Missouri, or whatever town it is. It's got to be specific to the place to be searched or the thing or the person to be seized. Now, if the Fourth Amendment is violated, then what is called the exclusionary rule comes into play. And what the exclusionary rule says is that if you obtain evidence in violation of someone's constitutional rights, then that evidence is excluded. It cannot be used against them at a trial. And this concept was originally established by the United States Supreme Court back in 1914 in the case of Weeks versus the United States. And since 1914, other cases have expanded this doctrine. Not only is the original evidence that is seized excluded if it's seized without a warrant or otherwise in violation of the Fourth Amendment, but also any fruits of the poisonous tree, that is, other information that you gained from the initial illegal information, that fruit of the poisonous tree is also excluded under these rules. And while these are federal cases, in 1961, this concept was extended to all 50 states through the case of Mapp versus Ohio. Now, there is one exception to the fruit of the poisonous tree, and that is if that information would have inevitably been discovered by law enforcement anyway, then it isn't excluded. But otherwise, fruit of the poisonous tree is excluded if the underlying information or evidence was seized in violation of constitutional rights. Now let's go back and use that Weeks case for the example. What had happened was law enforcement suspected, and they were correct, that Mr. Weeks was involved in illegal gambling activities. However, instead of getting a warrant, they went to a neighbor's house who had a key. They got the key and they went in and they got all the documents which essentially substantiated that he was involved in illegal gambling. Now, he was tried. They used this evidence against him and he was ultimately convicted. However, he appealed saying, hey, you searched my house without a warrant. That violates my Fourth Amendment rights, and this information that you gained should be suppressed and excluded from use against me. And the Supreme Court agreed, and it excluded that evidence for use against Mr. Weeks in his trial. Now, when we talk about the fruit of the poisonous tree, let's stick with the same factual scenario. So if law enforcement seized this information inappropriately and then it was excluded for use at trial, they could conceptually say, well, you know what? We can't use this against him. However, we know all of the people he was dealing with from these records. We know all of his customers. So we can go out and get a warrant. We can search their homes, get information from them, and then use that information back against Mr. Weeks. Well, the Supreme Court, under the fruit of the poisonous tree doctrine, has said you can't do that. You violated this person's constitutional rights. The initial evidence against him is excluded, and all fruits from that evidence also can't be used against him. So that's an explanation of how the exclusionary rule works and how it can expand to other fruits of an improper search or an improper seizure. Now, the important thing is that we start with the rule that law enforcement needs a warrant to search you or your property. However, the Supreme Court has carved out 8 basic exceptions to the warrant requirement where law enforcement does not need a warrant, where they can search you without a warrant, they can search your property without a warrant, and we're going to go through each one of those now. The first one is consent. If law enforcement beats on your door and asks to search your house or your apartment and you consent or you agree, they don't need a warrant. So that's something to keep in mind. And the expansion of this particular exception applies to forgive law enforcement for any search where they had consent from someone they reasonably believed had the authority to give that permission. Now let me explain that because it's a little complicated. I call this the girlfriend case. You've got a guy who's a drug dealer, law enforcement knows it, and he goes down to the Sip and Flip to get him a burger, right? So law enforcement beats on the door, his girlfriend's there, and they're like, hey, can we search? And she says, I don't care, come in and search. And so they go in and search, and they find evidence of illegal activity. Later on, the boyfriend says, hey, she didn't live there. She didn't own the house. She didn't have the right to give consent. The courts have said, hey, the officers reasonably believed she did have that authority, so the search is okay. So the first exception to the warrant requirement is if you give consent to the search. The second exception deals with a search incident to arrest. And this is if an officer places you under arrest, they can search your person. And the Supreme Court justifies this by saying you could have a weapon on you that you could use to harm them. You could also have evidence of a crime on you that if they didn't search you immediately incident to that arrest, that evidence might disappear. And usually we're talking about drugs. So if you get arrested, an officer is allowed to search your person. They're looking for weapons and they're looking for evidence of a crime. So they don't need a warrant to search somebody incident to an arrest. The third exception to the warrant requirement is seizing evidence that is in plain view. And the classic example of this is the officer who walks by an apartment and looks in and sees a bunch of pot plants growing in there. The officer doesn't have to go get a warrant. The officer can actually go in there and get those pot plants because it's in plain view. A lot of times you'll see this in a vehicle. Somebody gets pulled over for a ticket and they see a gun stuck down between the seats, or they see some other packet of drugs or something laying around. The officer doesn't need to go get a warrant because the evidence of the criminal activity is in plain view and a warrant isn't required. And while we're talking about being in your car, let's talk about the fourth one, the automobile exception. The Supreme Court has said because automobiles are mobile and because evidence of a crime could easily be driven away, that officers do not have to have a warrant if they have lawfully stopped an automobile to search that automobile. Now, there are limitations on this. The main limitation is that law enforcement can only search areas where the particular evidence they are looking for may be found. So if you are pulled over because your vehicle resembles a vehicle description in an Amber Alert or a potential kidnapping, well, the officer would be justified if they're looking for the child in popping your trunk and looking in there. But they wouldn't necessarily be justified in looking in your glove box or in the console between the seats because a child can't fit in there. So the one limitation on the automobile exception deals with scenarios where the officer has to look in areas where the potential suspected illegal activity or evidence is located. The fifth exception is the stop and frisk, or the Terry stop. That's very controversial. And the Supreme Court has stated that in limited circumstances where there is the reasonable suspicion of criminal activity, you can be stopped and in some cases frisked without a warrant. Now, an illustration of this point would be if a police officer sees a guy walking down the beach, it's 100 degrees and the sun's up and he's wearing a trench coat. And you'd be like, well, that's a little weird. That would give an officer a reasonable suspicion to go up and at least stop and inquire as to what the individual is doing. And then if that individual didn't give him a very good answer and the officer thought he might have a gun or something under that trench coat, that would give them the additional authority to do the frisk, the stop and then the frisk, because they suspected the potential of a weapon potentially under that trench coat. Now, officers have to have a reasonable and articulable explanation for why they are stopping you. But obviously you can come up with a lot of different reasons why you might have stopped somebody after the fact. Now, this is obviously a very controversial area. The case of Cleveland versus Ohio in 1968 brought this concept forward and has really been the subject of criticism in that racial profiling. Officers are stopping and inquiring with people who may be of a different race or those types of things. And so this stop and frisk exception has been under a great deal of criticism over the past 40 years for being the reason why a lot of African Americans get stopped and questioned by white officers. Now, moving on to the sixth exception to the warrant requirement, and that is hot pursuit. If a car chase is going on and they follow an individual into a neighborhood and that individual parks his car and hops out and runs into a house, well, the officer doesn't have to stop and go and get a warrant. That officer can pursue that individual into the house because they are in hot pursuit. So hot pursuit is the exception, the sixth exception to the warrant requirement under the Fourth Amendment. The seventh exception is called exigent circumstances or emergency situations. And a lot of times you see this come into play on domestic calls where an officer is responding to, say, a 911 call of a domestic incident, and when they get there the door's locked and they have to bust in because there's an emergency situation going on. And then once they are inside, they see drugs or evidence of a crime or a gun or whatever they see. However, in the circumstances of exigent circumstances or emergency situations, the officer doesn't need a specific warrant because the emergency put him into that particular situation. And then from there, he was able to observe criminal activity in plain view. So there's some kind of an overlap between these two concepts when we're talking about exigent circumstances. And last but not least, the eighth exception are border searches. And this is not really an exception. The Supreme Court has said it's not unreasonable. This is a reasonable search. Anytime you're leaving the country or coming into the country, to have your items, your person and or your luggage searched. And it's just for national security reasons. And the Supreme Court has said that is a search and or a seizure that doesn't require a warrant. So when we circle back and we think about the video we saw from the Texas LawHawk, we know that the officer was at the door. He was beating on the door and he was saying, "Let me in." But do any of the exceptions apply that would allow him to go in? Well, we know there wasn't consent. They never agreed to let him in. There was no arrest, so there couldn't have been a search incident to that arrest. There was no evidence in plain view. Now, he looked in the window, but all we saw were some guys playing Hungry Hungry Hippos. It's pretty sad, but it's not evidence of a crime. Next, the stop and frisk. That wouldn't have applied when you're dealing with somebody's home. Likewise, the automobile exception. They weren't in an automobile. That doesn't apply. There wasn't any evidence that he was in any type of a hot pursuit. We don't know what led up to him going there, but there was no evidence of that. I saw no exigent or emergency circumstances taking place, and it wasn't at a border. So no, that officer did not have the right to just waltz into that house. he would have needed a warrant, exactly like the Texas LawHawk told you he did. Well, that's the episode. I hope that you have enjoyed it. We had a little bit of fun doing a reaction to a video. We're going to continue to incorporate videos like that into these segments. If you've got something to say, comment below. If you want more material like this, I would invite you to subscribe to the channel. And as always, share me on social media.
Send lawyers, guns, and money.